When should grandparents consider litigation for visitation? Have you ever wondered when grandparents might need to take legal action to see their grandchildren? This is a significant concern for many families. Grandparents should think about litigation for visitation when they are denied reasonable access to their grandchildren. If they believe that maintaining a relationship is in the child's best interest, it may be time to consider legal options. Litigation is especially relevant if the parents are unfit or pose a significant risk to the child's well-being. This can include situations where there are concerns about neglect or abuse. Additionally, exceptional circumstances, like the death or incapacitation of a parent, can also warrant legal action. To proceed with litigation, grandparents must show that they have a substantial and positive relationship with the child. They need to demonstrate that denying visitation could harm the child's emotional or psychological welfare. In family law, courts usually prioritize the rights of parents to decide who can have contact with their children. Therefore, grandparents do not automatically have visitation rights. To obtain court-ordered visitation, they must meet strict legal criteria. This includes proving parental unfitness or showing that significant harm could come to the child if visitation is denied. The court will also assess whether visitation is in the child's best interest and, if it would not, harm the parent-child relationship. Before considering litigation, grandparents should gather evidence of their relationship with the child. This can include documentation of past visits, photographs, or any communication that shows a meaningful bond. If the parents object to visitation, grandparents must provide valid reasons for their request. The court evaluates several factors to determine if visitation benefits the child. These factors can include emotional support, stability, and continuity of family relationships. The court also looks at whether visitation would interfere with the parent-child bond. It is important to note that grandparents can only file for visitation once every 2 years. If there is a significant change in circumstances, visitation rights can be terminated. Cases often begin with preliminary hearings to assess evidence. Mediation may be attempted to resolve the issue before a final hearing takes place. In special circumstances, such as when one parent is deceased or missing, courts may be more inclined to grant grandparent visitation. If the remaining parent has a history of violence or abuse, this could further support the case for visitation. Preparing a strong case is essential. Grandparents should collect evidence that supports their role in the child's life and how visitation would be beneficial. It is also wise to be aware that litigation can be complex. Sometimes, the court may appoint guardians ad litem to representing the child's interests during the process. In summary, grandparents should consider litigation for visitation when they face denial of access, can demonstrate parental unfitness or risk to the child, and when maintaining the grandparent-grandchild relationship clearly benefits the child's welfare.